You're listening to Biz-Souls, the business podcast with an edge, hosted by me, Rona Lewis, and Jeffrey Hansler. Tune in for perspectives and discoveries about the changing world of business. It's time to connect to the heart, soul, and humor of how business gets done. All right, we are back, Jeffrey. Welcome, everyone, to another episode of Biz-Souls, the podcast that gets to the heart, soul, and humor of business and the people who make it happen. And we have one of those peoples.
Kevin Mayer.
That's right. Kevin Mayer. Yay. Hi, Kevin.
Hi, Rona. Hi, Jeff. How are you?
Very good. So we're, as always, we're learning, trying to make mistakes. And we started this like a minute ago, and we forgot to turn on the record button. So, we had to redo it.
Small thing. So let me finish introducing Kevin to everybody. Kevin is a partner at Norton Rose Fulbright, US LLP. I'm just reading the whole thing. I don't know if it's good or not. I'm just doing it. And he specializes in high stakes trials. He's a very important lawyer, works with product liability, OSHA, and mass tort actions. And we're going to go into that a little bit more, as well as other business and personal disputes. And Kevin, you've been working on some COVID things too, right?
And yes, actually, since the outset of the pandemic, which actually started really 2 weeks after I joined Norton Rose, we've been very involved in advising our clients throughout every industry imaginable in the United States and sometimes in Europe and elsewhere on issues pertaining to COVID, health and safety issues in the workplace, the vaccine mandates, various health and safety regulations that apply in various jurisdictions across the country.
Wow. So Fantastic. They just kind of threw you in there. Welcome, go.
So
that's pretty much
exactly.
So why don't we start with some background? Let's find out about Kevin. Why'd you become a lawyer? Where did you grow up?
Tell us
what
your
attracted
story.
You to law?
The executive summary of my life. So I have been practicing now for 38 years and started my career in San Francisco. My family is from San Francisco originally. It's been in the city since the 1870s. My mother is actually from Texas and moved to San Francisco after she had met my father. And I was the oldest of three children. My father was Chief Assistant District Attorney of San Francisco and then was appointed to the San Francisco Superior Court bench by then Governor Reagan in 1969. So as I was growing up, and I originally thought I would be an astronaut because I was growing up during the heyday of the space program in the 1960s. And then I decided I actually wanted to be an NFL quarterback. And there were two problems with that. One is I stopped growing, and the second is I didn't throw well enough. So that put an end to that idea. So by the time I got to college and realized that my football career as a quarterback was probably not going to be what I wanted it to be, I started focusing more on going to law school, and did so right after I graduated from college and right into the law. And as I say, I've been now doing this for about 38 years.
Wow. That's pretty good.
Fantastic. What did you, when you were taking law school, what was something that either stood out one way or another? Because right now, SCOTUS is making a lot of decisions and people are talking about things. And we had Thane Rosenbaum on our show, and he said law is not the way people think. It's the rule of law. You have to prove every piece and go through with every piece. I mean, what stood out for you about the law? Were there any surprises?
I wouldn't say so much surprise, but it really is a way of thinking about things. It's a construct that we put on the way we evaluate issues. And indeed, one of the real disappointments about the debate that is going on currently about what the Supreme Court is or is not doing is that people don't really understand what the role of the courts are in our society. Part of that is because I think they're being misinformed by the media. They are being misinformed by our political class. And as a consequence, people don't understand that they are a co-equal but separate branch of our federal system of government, both at the federal level and at the state level. And it is not the job of the courts to make the law. It is the job of the courts to interpret and apply the law. as it has been passed by the legislatures or Congress at the federal level. And so one of the things that we always talk about when we go to law school is that the point is to learn how to think like a lawyer. We don't look at things necessarily from a lay perspective, although we all have that. I mean, we are who we are. We're products of not only our internal personalities, but also our environment and how we were raised and the culture in which we were raised. But we have to learn how to look at things in a much more disciplined, academic, and rigorous way. We sometimes talk about issue spotting. And that's really one of the hallmarks of the legal education, is being able to spot the various issues that come up and then evaluate both sides of those issues in order to try to come to the right answer. The other thing that's really fascinating about the law, and this is really a product of having been in it as long as I have, is that we learn that there are three sides to every story, right? There's his side, her side, and then the truth.
Right.
And the reason we can say that is everyone will always have their narrative, and they will always talk about things that are consistent with the presentation of their narrative and tend to ignore or diminish or hide other facts which are perhaps not convenient to that narrative. And so one of the things that we as attorneys have to do is sift through all of that in order to try to arrive at what the truth is. And so, as I say, this is a more disciplined and academic way of thinking about things than perhaps what other people would go through on a day-to-day basis.
So can you say Dep Amber or
Deb Crawford, it would be.
Crawford?
Deb,
Oh, yeah, okay, to be consistent, right? Yeah. So with that requires a lot of patience. I'd be a lousy lawyer. How do you sit there through all that? Because you specialize as a trial lawyer, which is a specialty. I mean, there are a lot of good lawyers that, what was it, Goliath? That's the show going on right now. With, Billy Bob Thornton. Yeah. Yeah, he's a big trial lawyer. There are a lot of lawyers, and they never want to show up in court. They want to settle before. So it's a different skill set. And one of the things you're saying is it requires a lot of patience.
Well, and there are a lot of trial lawyers who are terrible. You know, I've not that I've been in a court of law a lot, and being Jewish and from New York, I know a lot of lawyers. It's just like the law, the law for us to have lawyers in the family and things like that. And I've seen an awful lot who are supposed to think like lawyers or think quickly or whatever, and they're just not very good. And they don't speak well. And that, I think, is half the battle to convince a jury of something.
See, Kevin's patient.
There's a lot of things that go into being a great trial lawyer. I'm not going to sit there and tell you that I am a great trial lawyer. Other people have to make that judgment. It takes a lot of courage to be able to go into a courtroom and advocate on your client's behalf, because that's what we're doing. We are trying to convince a jury of 12 and a judge of the righteousness of our client's position, that we should prevail in this matter for whatever the reasons are that we are advocating. The fact is, it's still true that well over 99% of cases settle or are otherwise resolved without going to an actual verdict at trial. Many cases will resolve during the course of trial. It could be while you're picking a jury, it could be after opening statements, it could be in the middle of the presentation of the evidence. It could be even after the case is submitted to a jury, and the parties will settle. But there are a few reasons why cases do have to go to trial and go to verdict. Sometimes it's because one party wants too much money, and if that's what they want, then they're going to have to get it from a jury, and they're going to have to hold on to it on appeal. Other times it's because a party feels that they have a position that absolutely needs to be protected and properly presented and advocated, not only in this particular case, but in the broader sense in the court of public opinion, whether they're protecting a product or a position or something of that nature. So there's a lot of reasons why a case might go to trial, even though we all recognize the vast majority still will not. And when we are asked to go into the courtroom and try a case on behalf of our clients, we know that there is a very distinct possibility that we could lose. We always know that. In fact, the standing joke among trial lawyers is You can't lose them if you don't try them. And it's sort of gallows humor, but you understand why I'm saying that. Anybody that believes that they're going to walk into a courtroom and by God, they're absolutely going to win is a fool, because they don't know what a jury could do to them. They don't know what those 12 in the box might hang their hat on when it comes time to deliberate. And they may be guided and influenced by things that in your wildest imagination, you never thought would happen. But that's why they decide the case the way they do.
Right. So do you like working for, big firms like this?
It's interesting. I've always, I guess, been in big firms. When I started my career in San Francisco, I was with a very old and respected litigation and trial firm that had been around for well over 70 years. And over the course of time, I sort of moved up to bigger and bigger and bigger firms. And now here I am at Norton Rose Fulbright, which is about a 3,000 attorney, we call it a Swiss Verein, with 53 offices worldwide, divided up into 5 different geographic regions. And of course, I'm in the United States region. But it's a very large, complex business that we have here, the business of the law.
Right.
When you were at law school, did you know that path, that career path you were going to take? Were you thinking big firms versus private law practice? Because that, first of all, it's you're forking out money for college and education, and so you got to be thinking, okay, where am I going to get where am I going to get, how am I going to make this back, and what do I want to do for my career?
Well, I'll tell you a funny story about that. When I went to school, we joke sometimes that it was back in the dark ages.
We're right there with you.
It was so much more economically viable to be able to go to college and to go to law school. When I went to the University of California, Berkeley for my undergrad, it was something like $250 a quarter to attend school. When I went to University of California, Hastings College in San Francisco for law school, it was $1,000 a year. And so I could pay for that out of my work money from the summer job and so forth. Now, of course, it's orders of magnitude beyond that, which is why it's such a difficult path for a lot of people, because they can't afford it themselves. They have to take out loans. They start in the hole. When I came out of law school, I would not say I made the most sophisticated decisions in the world in terms of how I was going to approach my practice. I knew I wanted to be in a litigation and trial practice. The firm that I went to in San Francisco, Bronson McKinnon, was one of the most highly respected trial firms in California. And one of the motivating reasons why I went there is because this was a firm that was full of athletes, frankly, a lot of college athletes, former high school athletes and whatnot. And so it just seemed like the right kind of people, the kind of people that I was used to associating with at the time, because I was playing rugby for the Bats in San Francisco. 3 of my teammates on the Bats were also attorneys at Bronson, and a couple of them were on the national team, and the firm was very good about letting them and letting us take time off from the practice to go on tours overseas to play, because it was important to them, probably from a public relations perspective as much as anything, to allow us that opportunity. And so I had the ability to do things for the first 9 years of my career that probably at other firms I never would have had the chance to do.
Kevin, were you ever going to catch you in Catalina at the old man's game?
Jeffrey plays rugby also.
I will tell you, I retired at 35 from rugby, and I never looked back. I was invited for pretty much every year to go play in Masters tournaments in New Zealand and other places, and I would think about it for about 2 minutes and decide that no, there's a reason I retired, and I'm going to stay retired.
Well, you took it up earlier, didn't you?
No, I took it up. I took it up at 42.
Okay.
I played from 42 till 50. Was C League, the Orange County Bucks. So we had a lot of fun. So
wow.
I played lock. And you're scrum half, or were you?
I was scrum half in college, scrum half and fly half. And then I went to fullback, and then I ended up as inside center at the end of my career.
Excellent. I think rugby, in hindsight, is a great analogy to law. So
Well, it's a team game. It's
Yeah.
when you think about it, it's the ultimate team game because whether you're a prop or a scrum half or a wing, everybody has to do the dirty work. I mean, once you're in loose play, everybody has to ruck and maul. Everybody's got to tackle.
Yep.
There's no prima donnas out there.
It's a tough game.
Oh yeah. Well, I knew at 50, the last game I played was in Cali, and I grabbed a guy's shirt and I heard fingers snap on both hands. And I said, yeah, the body is telling me it's going to go. It's just, real quick, getting back just before we leave kind of the background. Did you take summer jobs related to law, or did you take summer jobs to make money? And, were you in, what'd you do?
Well, both, I suppose. When I came out of college and I actually graduated early from Cal, I went to work for a law firm in San Francisco as a clerk. So I was sort of a jack of all trades. I would do the filing in the library. I would make the daily court runs. I would run errands for the attorneys. I would occasionally do some fairly simple research because at that time I wasn't in law school and I didn't know how to do it properly. And then I went back and worked for that firm again after my first year in school. And then my second year, between second and third year, I worked as a summer associate at Bronson McKinnon, which is why I got an offer to work there after I graduated.
Nice.
Very, very good.
So how much now is your business OSHA related versus other work?
The OSHA practice has probably been consistently about a quarter of what I do.
Mm-hmm.
And the OSHA practice itself is pretty much a soup to nuts analysis. We've done everything from workplace compliance counseling to audits to internal investigations of incidents that are OSHA reportable, helping with the negotiations with the OSHA investigators to try to avoid our clients getting citations. And then, of course, if they do get citations and we find that there's a reason to appeal them, we will appeal them, litigate it, and then if necessary, take it to an administrative law trial before an administrative law judge. Mm-hmm. And so over the course of roughly 25, 27 years, I would say it's been about a quarter of what I've done.
What else takes up your time?
Well, the active civil litigation piece. So the product liability, the toxic tort, the mass tort work. And now, since I've been here, we're starting to branch out and doing more plaintiff commercial work on a business to business basis, which is a fascinating new frontier, not only for me, but for the firm.
Can you talk more about that and explain a little bit more what that is?
Well, and mass tort and
toxic tort. It's like,
okay. Yeah. So let's talk about toxic tort.
Pretend we're 5 years old. That's just me.
No, pretend we're in our 60s and we still don't.
I have no idea.
Right. So toxic tort litigation involved claims that people say they developed either some form of cancer or systemic disease or perhaps birth defects or reproductive harm as a consequence of chemical exposures, whether from consumer products or occupational exposures in the workplace. And so it could be literally from anything, from asbestos to silica to welding fumes to petrochemical solvents to hydrocarbon solvents to chlorinateds to every chemical that you can imagine. And so it's really quite fascinating because I fell into this practice purely by chance when I was a second year attorney, and we had a lateral partner come over to Bronson from another firm, and this is the practice he had, and he needed a bright young associate. And so the chairman of our firm asked me if I would be willing to get involved in it. And I said, sure, it sounds great. And that's how I fell into this. And the reason I say it's fascinating is I had no background in the hard sciences or medicine, certainly in college or law school. And over the course of all the years, I would say now I know enough to be dangerous. Not be a doctor, but I play one in the courtroom. And it's fascinating because I get to associate with some of the world's leading experts in the various medical and scientific disciplines that are involved in that. Wow. When we talk about mass tort litigation, we're simply talking about a situation in which there could be many scores, dozens, hundreds, thousands of people who are alleging a similar harm as a consequence of our client's product or a particular type of exposure or some incident that has occurred. So for example, if you're doing medical device litigation and all the patients who had an implantable device placed within their body and claim that the device failed in some way and caused them harm. You could be dealing with hundreds or thousands of such patients, including those who may not have been harmed yet, but claim that they fear being harmed in the future.
So what's the difference between that and the class action suit?
So a class action is a mechanism whereby a group of smaller representatives, could be as few as one, sometimes two, three, four, five, named plaintiffs are bringing an action on behalf of a class of allegedly similarly affected people. And the point of a class action is that it's a process whereby a court says there is sufficient commonality of the factual issues and or the legal issues that resolving them through a class action is more appropriate and more efficient than it would be to try to resolve each of these individual claims separately.
I see.
So what happens is the named representatives and their attorneys will bring the case, and assuming that eventually they can get the class certified by the court, then usually these cases don't go to trial, they will be resolved, and then some form of relief to the class, whether it be a payment of money, the issuance of certificates that give them something, some form of relief is made available to the class. And then the class members have the ability either to accept that or to opt out of that and then pursue their own lawsuit if they choose to do so.
So the Johnson & Johnson talc case, talcum powder case, would that be both toxic and class action, or is it, how do you classify that one?
So here we're talking about the allegations that Johnson & Johnson's talc products were contaminated with what are referred to as asbestiform minerals, a form of asbestos. And that as a consequence of that, people who were using Johnson & Johnson talc developed some form of cancer. If it's a woman, it could be uterine cancer, something of that nature. Those are toxic tort cases by definition, because the claim is some external exposure caused disease in a human. They are typically not, however, subject to class action treatment. And the reason is because the circumstances of each individual case are sufficiently different so that there are not common questions of fact which predominate over the uncommon questions. And this is typically the case in all toxic tort matters. We are usually quite successful in preventing classes from being certified because the circumstances of the individual cases are simply too different.
So, did you have a question related to that?
Well, I did.
Oh, go ahead. No.
No.
I was going to change the subject, so go right ahead.
No, go right ahead. and change the subject.
No, I'm curious to know what is a day in the life of Kevin Mayer like? Like, what do you do all day? You know, what things do you do more research? Are you calming clients down, or, you know, walk us through a day?
Yeah, every day is something different. Some of it's the same. Like I wake up at between 4:45 and 5 a.m. because the pets all want to be let out and fed. And then I go and do my workout at 6 a.m. If it's during the school year, I might have to get home, eat, drop my kids off to school, whatnot, and then get to work. So a typical day could consist of a lot of phone calls and emails and working on briefing. If we're in the middle of an active litigation, we could be taking depositions either by video or live in some jurisdiction. Sometimes I'm traveling to other parts of the country to meet with the clients, to meet with witnesses, to do litigation-related things, appear in court, what have you. So every day is something new and different.
Cool.
Okay.
Yeah.
So jumping back to,
Okay. See?
so now, and I don't know if I was picking up any body language. So when we talk about a specific case, maybe we can't do that. So I'll relate it to I'll start it off at the J&J case, and then we'll generalize it. So in that case, one of the things we get involved in, partner and I, are organizational development issues. And we talk about the effect management has on things and the culture has on things. So for J&J, the culture seems to be Even though they put close to, I think it was close to $12 billion in other liabilities as a requirement of the lawsuits that were going against them, management still really completely downplayed. And I don't think management ever accepted. They basically said, hey, this isn't the case, and we're going to defend it. So even though they've been losing the lawsuits, they lost several of the lawsuits, they were still defending and denying it. So how do you get into preventative with organizations and start talking about how management is communicating, or executives are communicating with their stockholders, their shareholders, and with people? Do you get into the culture at all as part of a preventative thing, or do you guys stay strictly on, hey, we have a case, we'll deal with the case, that's it? And like the CEO of Uber, who is creating problems for the organization, or do you get into it and say, hey guys, you do have an ongoing issue here?
Well, it's an excellent question. And the answer is all of the above and none of the above, because it really depends on the specific circumstance. I will give you an example. And I'll say up front, I do not represent Johnson & Johnson in those cases, but I do know the science and the medicine in those cases quite well, because I've been involved in other talc-related matters. And I can tell you that there is a real dispute between the plaintiffs and the Johnson & Johnson position about whether there is any asbestos in their product, and even if there was, what can it do or what it cannot do. And so those are what we call triable fact issues that have to be submitted to a jury for decision. And indeed, Johnson & Johnson has won quite a number of these cases as well. And so that then gets us into the next part of this, which is risk management. A lot of what happens in litigation is risk management, risk control, risk resolution. And so if you are dealing, for example, with mass tort litigation, let's say you're defending a product which is alleged to have caused or threatened to cause injury in hundreds or thousands or tens of thousands of individuals, that's a pretty big potential liability for the company. Do you intend to try 10,000 cases? No, probably not. So either you're going to steer this in a direction where the cases can be resolved to the satisfaction of both sides. And we have a saying in the law that the ideal settlement is one in which neither side is happy, because the plaintiffs are having to accept less than they wanted, and the company is having to pay more than it wanted. But at least they get resolution as a consequence of that. So there's a lot of this that has to go on. And indeed, sometimes we are called upon to make presentations to the C-suite of a company, to make a presentation to the board of directors, to educate them in conjunction with our in-house colleagues at the company as to what the risks are and what the prospects are for success. And success has to be defined, of course, in terms that the company wants to define success as. Does that mean going to trial and winning? Does that mean resolving this massive piece of litigation so that it can be put behind the company and they can move on to other things? These are always important conversations that have to occur at the very outset of any undertaking of significance.
There you go. Do you want?
So
Go ahead, ask a question.
well, if you got one.
Well, I'm just, I'm looking at, in terms of, I'm going back to OSHA. Does OSHA do anything to prevent frivolous lawsuits? You had the story with your wheelchair guy.
Well, there are a couple of characters. Huntington Beach is known for its character, both good and bad. And 4th of July is coming, and we'll see what happens here.
It'll be entertaining, I'm sure.
Yeah, it will be entertaining. There are a couple of characters that would focus on downtown restaurants and businesses and get them for OSHA. They would go in ADA a lot of times. If the bathroom was open to the public and it wasn't ADA or OSHA compliant for that. And that's a distinction too, you might be able to make for us, the difference between ADA and OSHA, because I know they cross paths. So, and they would go down and they'd start a lawsuit. And the idea was, and they had a specific group, a small firm of lawyers, that this is what they did. And they just went after it, and they were looking for a quick settlement. How to
Yes.
get, so anyway.
We see that all the time. And there is a distinction between OSHA and the Americans with Disabilities Act, which I think is what you're referring to here.
Right.
And I see this all the time. When I look at the advance sheets every day, I see that there are ADA claims being filed every day, usually by the same small group of plaintiff firms here in Los Angeles County and elsewhere, with the same group of quote unquote disabled plaintiffs who are going into workplaces looking for violations of the ADA that they can turn into a lawsuit. We have the same situation with California Proposition 65, right? The warnings about chemical exposures. We can talk about that if you like. Now, by contrast, OSHA, which stands for the Occupational Safety and Health Administration, or in the federal parlance, the Occupational Safety and Health Act, is designed to provide a safe and healthful work environment for employees.
Oh.
So it's a little different. OSHA typically does not result in civil lawsuits. It gets handled at the administrative level. So for example, if an incident occurs and someone is killed or injured in the workplace and it has to be reported to OSHA, OSHA will then start an investigation. They will look at whether there were certain conditions, circumstances in the workplace which caused this incident, which resulted in the death, the injury, the destruction of property, and whatnot. And then they will decide whether to issue citations. If so, whether there are certain fines that are associated with that based on the classification of the citation. In other words, is it general? Is it serious? Is it serious and willful? And then what steps in mitigation or remediation they will require the employer to undertake in order to cure the problem, in order to make sure that this does not happen again. Then if the employer doesn't like it, if they decide, no, we feel that we were wrongfully cited for this, and we actually didn't do anything wrong, we think that our policies and procedures were spot on, and this incident actually was caused because a worker did something wrong that violated their training, then they can appeal that. And then we go through the litigation with OSHA, where we will get their investigative file. They will ask us for our investigation materials. We may depose the OSHA investigators. We will sit down then with OSHA and try to resolve the matter, to settle it, which could result in the dismissal or the lessening of the citations, the reduction in the fines, and so forth. And if that can't be done, then we will go try the case to an administrative law judge, which is a single judge sitting without a jury, who makes these decisions. Now, there's a possibility that if we don't like what happens to us there, that we could then file a civil lawsuit for mandamus and then take the case to the Superior Court. In my experience, I have not had to do that. It doesn't happen very often at all, because again, you're usually able to either resolve these things with OSHA before the hearing with the judge or as a consequence of the hearing with the judge.
I actually, I had a client a few years ago who they called me in to help with get their people online. It was I can't mention names, obviously. There was it's a medical cancer research, things like that. And it's in LA County. And they brought me in to look at their labs where their people were working, because they were breaking OSHA rules left and right. Sharps were out in the middle of, anywhere with the top so the garbage can open, and there were chemicals that if they mixed in the sink would go boom, and the people weren't listening because they were doctors and PhDs, and they know better, and it wastes time putting things back, and they were at their wits' end. And I was called in to try to help the corporate culture, because the C-level were like, we don't want the lawsuits and this and anything happen, and how do we get these people to listen? So I came in at another angle, and it's not easy a lot of times to get employees to really go, by the OSHA rules.
It's really a fascinating situation, because there is this tension that exists in a lot of workplaces between the employer, who is trying to do the right thing and is trying to make sure that they're complying, and, shall we say, reluctant employees
Good word.
who think that, oh, this is just necessarily complicating it and getting in my way and so on and so
Exactly.
forth.
Exactly.
By the same token, we have seen workplaces where the employer has not been as rigorous about their observance of OSHA standards as they ought to be. And then things get brought to their attention, they get swept under the rug, they get ignored, or perhaps there's even retaliation against the employees for raising it, which is also a big no-no. So we see it at every gradation that you can imagine.
Is a couple of questions. Is California different from the other states with in regards to OSHA? Are they more intense? Are they more active? Are they more, I don't know, watchdog?
Okay, an excellent question. I'm glad you asked it. So the Occupational Safety and Health Act came into existence in 1972 when it was signed into law by President Nixon. And that's what established federal OSHA as a division under the US Department of Labor. So you have among the 50 states that follow the federal OSHA program, and then other states like California, which have a federally approved state program. And in order to get that federal approval so that you can run your state program, you have to be at least as rigorous as the federal program. So in other words, whatever federal OSHA says, your state has to do at least that much and require at least that much, but they can do more. And California is an example of one of those states where, in fact, they do more. And in fact, we're dealing with an issue right now where California is trying to change the existing standard on lead exposures in the workplace. And they would seek to require certain protective measures to be taken that may or may not apply to specific types of workplaces. And we're being asked to look at that on behalf of clients because they don't believe that the proposed revised standard has direct relevance or application to their workplaces, and in fact would impose undue burden and expense on them and not achieve the result that OSHA wants, which is occupational safety and health. So these sorts of things do come up.
And one of the areas that California OSHA are the penalties stiffer in California than in other states?
So over the course of time, the penalty amounts have increased. And again, it depends on the gradation of the citation that you receive. So you could have a general or administrative citation, you could have a serious citation, then the biggie is a serious and willful, and even bigger than that, a serious and willful repeat, which means that you got cited for a serious and willful before and you haven't changed your attitude or your approach to things. So the penalties go up as the gradation of the citation and the number of offenses go up. Now, one of the things that OSHA of late has been fond of doing is citing or issuing multiple citations for the same offense. In other words, if one citation is good, 3 is better. And that's actually an explicit violation of guidance that has been issued both by the courts and by OSHA itself. You're not supposed to issue multiple citations for the same offense if one will do the job. But they do this because they think that that gives them negotiation leverage when you sit down to try to resolve these things. You know, we had a case once where we had 9 different citations issued for an explosion incident in the workplace when 3 would have done just fine. And the point was that they wanted to use that to force us to accept at least 4 of the 9 in a resolution. And we got that all squared away.
It's
But
very
that was
sneaky.
being
And the purpose is collecting penalties, or the purpose is compliance, or the purpose is what? Somebody's career within OSHA, like look, you know, kind of like how they. Sorry.
It's all of the above, Jeff. It could be that somebody is looking to have, if you'll pardon the indelicacy of the expression, scalps on the wall. It could be because they feel that they need to meet a quota of issuing certain citations. It could be because the incident had gotten a lot of publicity. You know, it happened in a very public way. Perhaps a lot of people got injured. Some people might have gotten killed. And therefore, they feel that they need to make a splash by issuing a bunch of citations to show how seriously they're taking the situation. It's not so much about the money, because when you compare the penalty amounts versus what might be at issue in a civil lawsuit, it's not comparable. I mean, the fines are relatively minor compared to what potential civil liability might be in a lawsuit situation, where you might have millions or tens of millions of dollars at issue, as opposed to at maximum tens of thousands.
Interesting. I don't know if this has to do with OSHA, because full disclosure, most of these are Jeffrey's questions. He was very astute and wonderful with how he listed these, and I give credit where credit is due. I know my limitations. Is it PAGA, P-A-G-A? And why is there a focus to change it?
So PAGA is the Private Attorney General's Act. And what this stands for is, we allow in California private citizens to bring an action on behalf of the people of the state of California in order to assert and protect an important public interest. And if they were to prevail in their lawsuit, then under the terms of the Private Attorney General's Act, they can petition the court for an award of their attorney's fees as plaintiffs, in having brought this in order to vindicate an important public right. We see PAGA lawsuits typically being filed in this state in the labor and employment context. I will tell you up front, I am not a labor and employment attorney, and a couple of my partners here in California are experts in this area, and I'd be happy to introduce you to them if you'd like to get a more thorough discussion. But every so often, we do see PAGA claims being asserted against our clients in the context of product liability, mass tort, toxic tort suits as well. It really doesn't fit particularly well in that circumstance, because they can't show that the type of claim that they're bringing really belongs within that PAGA regime, but that doesn't stop them from asserting it anyway.
So related to that, okay, so some of the new, because of the Roe v. Wade decision by SCOTUS, the states are enacting laws. Some of the states are saying, yeah, we have a tattletale law, but they're not calling it that. That if you know somebody's getting an abortion in the state, you personally can bring a lawsuit, like an Uber driver that was driving somebody to an abortion clinic in one of these states could technically. Is that related to PAGA, or just
that it sounds to me would be more akin to what we would call a whistleblower claim. Okay. Now, whistleblower claims typically occur within the employment environment, where you have an employee who is claiming, sometimes it could be somebody at the management level too, by the way, who's claiming that the company is doing something wrong. Perhaps they're defrauding the government, or perhaps they're violating safety protocols knowingly. And the whistleblower asserts a claim, and there are certain laws that pertain to how that gets handled and what compensation might be due to the whistleblower if they're successful in bringing the lawsuit, or the government takes over the case and they win, and then the whistleblower gets some money out of that. So the circumstance that you're talking about, and I've heard about this, I have not obviously experienced any of it, strikes me as being closer to a whistleblower situation than it would be to the PAGA situation. Yeah. But it does come out of statute. In other words, if the state legislature is enacting a statute that conveys this right on a private citizen to make the claim, presumably that statute also indicates what sort of compensation they might be due upon a successful claim.
Okay.
Cool. I would like to bring the subject around to COVID and what's been going on with that, and how companies are reacting to it. Is there, are there things that have changed? Are there things that need to change? Are people, companies complying? What are you finding on your end?
So we have to talk about this in terms of local and state, and federal. And I'm sure everybody's aware that things are happening in each of those types of jurisdictions with various distinctions that we'll talk about. So in most situations, and we can use Los Angeles County as an example, the Los Angeles County Department of Public Health articulates policies and procedures and requirements that apply to workplaces within the county, which is why we had mask requirements indoors, including in restaurants, grocery stores, office buildings, gyms, airport, what have you. The state would also, through the State Department of Public Health, would have their requirements. And state OSHA, our Cal OSHA, for example, came up with an emergency temporary standard for COVID-related workplace health and safety issues that had to be observed in various environments. Then, as you're probably aware, the Biden administration had federal OSHA try to come up with an emergency temporary standard that talked about the necessity for vaccinations and so forth. Ultimately, as we all know now, the Supreme Court threw that out. And it was, in my view, completely justified in doing so because federal OSHA, A, did not have the jurisdiction to act as it acted. B, COVID is not a workplace hazard per se. COVID exists ubiquitously in the environment. And so whether it comes into the workplace or it's outside of the workplace or at home or in a restaurant or movie theater or whatnot, it simply exists. It doesn't exist in the workplace by virtue of the activities that are occurring in the workplace. And so there was a very strong argument that this was not an area in which OSHA was entitled to, if you will, issue an emergency temporary standard. As important was that OSHA did not observe the proper process for pursuing an emergency temporary standard. And that was also a factor that was argued. And when I actually listened to the oral arguments in front of the Supreme Court, both pro and con, for trying to justify the standard. And it was interesting to hear the questions that were being asked by the different justices and ultimately what the written decision said when the majority invalidated the emergency temporary standard and the minority tried to justify it, not for any of the legal reasons that we've talked about, but just because, well, this is a public health emergency and we've got to do something. And that's not a good legal justification for doing anything.
Right.
True.
Very
Did you
good.
have a question?
Well, is there, we're kind of coming, we're coming to a good close time. Is there anything we should have asked, or is there anything that you really want to talk about that,
People don't necessarily know about or should.
or a funny story about OSHA, which how can it be funny when there's so much money involved in, and everybody's, so anyway, or something like, yeah.
So I think I would leave you all with two big picture observations, one about OSHA and then one really about the law itself. OSHA is an important function in our society. As I said, its purpose is to provide a safe and healthful work environment for employees. We don't want people to get hurt or killed. We don't want property to be destroyed. You know, I used to do a lot of OSHA work for a refinery here in Southern California. You know, we weren't baking cookies out there. This was a place that was refining petrochemical products and gasoline and jet fuel and solvents, very dangerous activities. The companies at that refinery did not want to perform their work unsafely because the consequences could be quite dire. And sometimes it felt like OSHA was treating us not as a colleague with whom they should be collaborating, but as the enemy. And that was not the right approach in my view. And so we actually had to take to trial quite a number of citation appeals, and were successful in those because we demonstrated that OSHA was perhaps not behaving in the way they should have, and they shouldn't have issued the citations. But by and large, it is important to provide this superstructure for employers to help them protect their employees and keep them safe. The second observation I would have about the law generally, and we can talk about this in terms of the court system, is people need to remember that the United States is not a democracy. The United States is a constitutional republic, and there is a difference. And we see that difference most starkly now in the decisions that are coming out of our Supreme Court. The powers and the rights that are not explicitly conveyed in the Constitution to the federal government are reserved for the states. That is our system of federalism. And so we can debate the legal niceties of the approach of any Supreme Court decision that is looking at whether a law is or is not constitutional. But people have to understand that the judicial branch is not a legislative branch of government, and it is not an executive branch of government. Its job is to interpret and apply the laws as they are written. And that's an important distinction that sometimes we lose sight of, and the media lose sight of, our political class lose sight of, on every side. This isn't a one-size-fits-all argument, but we have to understand that the judiciary needs to be independent as a co-equal branch of government in order to do its job free of undue influence. And so that's what I would say about that.
Well,
thank you.
Very,
Excellent.
very impressive. Kevin, this has been incredibly enlightening, and I so appreciate you. We so appreciate you taking time out to explain these things to us lay people, to try to help others understand, your aspect of the business and why all these things are important and in place.
Well, it's certainly been my pleasure, and I very much appreciate you all taking the time to chat with me.
Definitely want to speak to you again at a later time and have you back on. In the meantime, we'll probably debrief with you and find out, okay, what else could we have asked? What could we have done to find out more? Any, do you have a final recommendation for businesses in general? How can they either be better prepared? What can they do to avoid litigation? Any strategy should they take? How much attention should they give to OSHA?
Or any
or should they have
related things like
that? Yeah, I mean, does HR handle OSHA requirements, or is
It can,
within a
depending on the size of the company, there could be a separate environmental health and safety function that has responsibility for OSHA compliance, but in many places it's handled at the HR level. And perhaps with outside consultants to advise them on these issues, because it is a very technical area. So my advice to employers is know what your obligations are under the law, identify the hazards that exist in your workplace as a consequence of the activities in which you are engaged, understand what you need to do in order to keep your employees healthy and safe. And if you have questions, call OSHA, because part of what they are there to do is to work with employers to help them establish this safe and healthful work environment. If you call them and ask them questions, ask them to help you, they're not going to come out and start citing you right and left unless they see something that's just, of course, completely egregious and there's no excuse that it's there. That's not what they're there to do. They're actually there to help. But it's when the incident occurs and they have to come out and all of a sudden they find all these things that are wrong, that's where you get yourself in trouble. And we want to avoid those sorts of things. That's what risk management really is. Know your obligations, do the necessary investigation, and take the steps necessary to meet those obligations.
Fantastic.
All right.
Kevin, thank you so much.
This has been awesome. Thank you so much. It was, thank God Jeffrey came up with these great questions, because I was the color commentator, obviously, and I accept that role every so often. And Kevin, thank you for also being my friend and understanding that.
See, that was the thing. This wouldn't happen if it wasn't.
That's right, because it's all about you and me, Kevin.
There you go. It's been a pleasure, Rona, and Jeffrey, thank you so much. It's been great to make your acquaintance, and
Yes.
I'm glad we could do this today.
Thank you. Yes.
Thank you, Kevin.
You have been listening to Biz-Souls with Kevin Mayer, esteemed trial lawyer and partner at Norton Rose Fulbright. I'm Rona Lewis.
I'm Jeffrey Hansler.
Thanks for listening. We'll see you later.
Thank you.
You've been listening to the Biz-Souls podcast with your hosts, Rona Lewis and Jeffrey Hansler. Did you have fun? Subscribe, rate, and leave a review. It's very much appreciated. Talk to you next week.